Okay, so
Nice, nice thing, isn't it?
it is. This is level 2. So we share. That's the drug court down there, 2.1.
Okay.
Here,
Yep.
in 2.2, that's part of local court. On this level as well, we have the probation parole room with Australia.
Okay.
It's a voluntary service, so they come out on our list days.
Victims and witnesses of crime.
Correct.
Court counselling service.
Correct. So they come out Tuesdays when. So this is our remote witness room. This is the soundproof floors in all the rooms that we have
Yep.
here. So the witness, once the courtroom is ready to go, it's all managed from the court's end. Here the witness can ask from the bar table, whether it be the prosecutor or the defendant solicitor.
Okay.
We'll always ask from here. The witness sitting in this chair can only view.
So the cameras swing around to other.
No. This can be adjusted only in the view of the witness.
So, counsel or prosecutor, lawyers just shuffle chairs.
Correct. They will need to shuffle around.
Yep.
That's with local and district court, but local court as well. District court, the sheriff officers will be
Okay.
will sit in with them.
And the swearing in takes place.
All on here, it's possible.
And does the magistrate say that the witness is here in Parramatta or
room with the witness.
Okay.
And our technology upgrade has been upgraded recently in the last couple of
Yeah.
months. So we've got assistance here. So this is also for impairment.
So you never have interruptions to transmission because of failure or very rare?
In-house call,
Yeah.
so it's very well. We do have assistance here for impairment, for witnesses that are impaired through their impairment on their ears, and they are able to hear much better.
Okay.
So we've got that all set up. And we can, the witness has the option.
And on a typical day, you've now got 3 remote.
But that's just generally for not particularly for complainants. It's
And
just
on how much use does one of these rooms get?
used.
Mm.
On a typical day, we had one yesterday actually, and no, not through here.
Does the witness get a little?
Okay, so here
They
we
can,
go.
they can see what they look like.
Yeah.
You can see how I look like I'm
Yeah.
looking down. If I look up there.
So you can either maximise yourself here,
Mm.
and then I can remove that from there. So the witness can always view themselves if they wish
Yeah.
to view.
Okay.
But yeah, the camera is adjustable
there.
through here.
Yep.
But
Okay.
the witness is not to know this. You need to zoom in. I can't see the witness. We'll just
Yeah.
zoom in a bit more. And then
There's a court officer here. Yeah.
will always be
Yeah.
here. So the court officer and the court officer in the courtroom will always liaise.
Yep.
So they'll do a test run prior to the magistrate walking on, whilst the witness will always
Yeah.
be, oh, can you see me? Can you hear me? Is everything okay? So
So, if
this counsel is sitting here, and then this other counsel sitting there.
they'll be here one day.
They will be here, but they can shuffle around.
Okay.
So we
Yep.
overruled on that.
Yeah. Okay.
Yeah.
This is a
So you get that little screenshot at the top of the
So
screen.
what normally happens is
This was the old seat. They can they're not tied up, and they are still being transported up and down through downstairs. It's just at a different area because the construction has been going on with the seat across the right, and we're not able to see anything else. And yes, they need to be flush against the wall.
That's pretty good. I mean, everyone can see that.
Yes.
Some court
Mr. Speakman, why are these new facilities so important for witnesses?
This is about cutting the re-traumatisation of victims and witnesses who come to court. Often those who come to court have been through incredibly traumatic experiences. Coming to court just adds to that trauma. We want to make sure there's fairness to an accused, but at the same time reduce the re-traumatisation of victims and witnesses to come to court. So we're rolling out across New South Wales the latest audio-visual technology to make sure that vulnerable witnesses can give their evidence remotely, still be subject to scrutiny and cross-examination by the court, but in a safer environment. That's a win for complainants. It's also a win for the justice system. It means complainants are less traumatised. It also means they can give clearer, more reliable evidence, which leads to more reliable outcomes.
And these are part of a whole range of reforms that have been put in place to help these witnesses be empowered to give
Sure.
their...
We've installed new remote or safe rooms or engaged in major upgrades at 45 locations across New South Wales. That work is finished. We're also undergoing 110 major upgrades or installations of audio-visual facilities in courtrooms right across New South Wales. So this means our court system will have the latest technology for more efficient and fairer justice and less trauma to victims and complainants who've gone through often horrific circumstances, and we want to cut the impact of that re-traumatisation when they come to court.
And what about law reforms? What have you done in that area?
Well, as a government, women and children are our number one priority. As a government, women's and children's safety is a top priority. It's not just about equipping the courts with the latest technology and building infrastructure for remote and safe rooms, but also law reform. We've introduced an affirmative consent model of sexual assault matters in New South Wales. We have introduced coercive control legislation where we know that victim survivors of domestic abuse will often tell us that worse than the bruises and the broken arms, the psychological, social, spiritual, financial, sexual abuse that perpetrators inflict upon them in a systemic way. We have introduced new jury directions to explode rape myths that often disadvantage complainants when they come to court. We've banned the direct cross-examination of self-represented accused in criminal domestic violence and related proceedings, and introduced a presumption in favour of remote evidence or closed courts in a criminal domestic violence case.